Hi everyone, welcome to my channel. So this video is specifically for CA foundation students. So the foundation students who wants to learn law subject, then you are at the right place. From today onwards I am going to start the series or session or videos on law part, okay, law chapters. So whoever wants to learn the CA foundation law at a free of cost and with the ICAI study material, then please subscribe to my channel and share my video and like and comment. Okay, so today let's get started with Indian Contract Act 1872. So this is one of the important chapter here in this law subject. So directly we will start with the contract part here. Okay, what is contract, what contains the contract, etc. So here you can see the term contract is defined under section 2 subsection H of the Indian Contract Act 1872. Okay, so the meaning of the contract is under which section? 2 subsection H. Okay, so how to read these sections? If this 2 and this bracket H, the bracket H is called as subsection. Okay, for example, here you can see this is section 2, and if you are writing it in bracket, this becomes as subsection. If you are writing in another bracket, then this becomes clause. Okay, so section, subsection, then clause. If there is another thing, then this is called as subclause. Okay, like this we can read the sections. So here you can see this is under section 2 subsection H of the Indian Contract Act 1872. So the what contract means is, contract is an agreement enforceable by law. So contract is an agreement which is enforced by the law. So here you can see contract contains two essential elements or important elements. First one is an agreement, okay, and that should be enforced by law. Then it becomes the contract. If in a agreement or if in a contract there is no agreement or there is no enforceability of the law, then that does not mean it is a contract. Okay, so whenever you are meeting with someone, whenever you are agreeing to the terms and conditions of the specific task or activity, then if you want to enter into a contract, firstly there should be an agreement between two parties, and the second thing is there should be some terms and conditions which is contained in the law. Okay, then it is called as contract. So here you can see uh, what do you mean by agreement here. Okay, so the agreement given in section 2 subsection E, so the contract is given under section 2 subsection H and the agreement is given under section 2 subsection E of the act is defined as every promise and every set of promises forming the consideration for each other. Okay, so what do you mean by agreement? If there are two parties to the contract, then these two parties make promise or set of promises. Okay, there should be one promise or more than one promise. If there is one promise, then it is called as promise. If more than one, that is called as set of promises. Okay, so if these two parties are coming together and agreeing to some promises or making promises, and in turn if these two parties are getting some considerations, then it is called as agreement. Okay, for example, if two parties come and one party says, I will promise you to pay 10,000 rupees, in turn of that 10,000 rupees you should provide me a laptop. Okay, in this case this party is promising to pay the amount to this party and this party is promising to pay the laptop to this party. So here the promise becomes the promise of paying the amount and promise of delivering the laptop. Then The consideration, what is consideration? For delivering laptop, the consideration is the amount of 10,000 rupees, and for paying 10,000 rupees, the consideration is getting laptop. Okay, so whenever there are set of promises between two parties in terms of, or in like with the consideration, then that is called as agreement. To have insights into definition of agreement, we need to understand the promise first. So section 2 subsection b defines promise as when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. The proposal when accepted becomes a promise. Okay, so here one person comes and makes a proposal to another person that he will pay 10,000 rupees. Okay, when he is proposing to pay 10,000 rupees in terms of like for purchasing laptop. If this party agrees with this party or accepts his proposal that okay, I will receive this 10,000 rupees and I will deliver laptop to you, then if when he accept this proposal, then that proposal becomes a promise. If he rejects this proposal and he says no, I don't want 10,000, I want 20,000 rupees, then this is not called as promise. But when he is agreed to 20,000 rupees, then that is called as promise. Okay, so whenever one person is promising or when person is proposing something and the next person accepts that proposal, then that becomes a promise. Okay, so first we will learn what is promise. Promise is when a person to whom the proposal is made signifies his assent. Assent means accepts. Assents thereto, the proposal is said to be accepted. Okay, proposal when accepted, it becomes promise. Okay, once you have a promise, those promise or set of promises in terms of or in return of consideration, whenever those parties agree to those promises and the consideration, that agreement or that consideration or that concession becomes the agreement. Once you have the agreement and you are tying those agreement or terms and conditions with the law, then that becomes your contract. So here you can see the following points emerge from the above definition. First one is when the person to whom the proposal is made. Second one is signifies his assent on that proposal which is made to him. The proposal becomes accepted, then the accepted proposal becomes promise. Okay, these are the points which comes from this definition, promise definition. Thus we say that an agreement is the result of proposal made by one party to the another party, and that other party gives his acceptance thereto, of course of mutual consideration. So agreement here is offer plus or proposal plus acceptance plus consideration. So agreement includes these three elements. These three elements must be there to term it as a agreement. First one is offer or proposal. One party should propose or offers to another party, then second party should accept that proposal, and both the parties agree for some consideration. In that case it becomes agreement. Now coming to enforceability of law, enforceability by law, what do you mean by that? An agreement to become a contract must give rise to a legal obligation, which means a duly enforceable by law. Okay, if there is no legal obligation, if there is no terms and conditions, then if you are agreeing to some conditions or some activity or some consideration and there is no legal obligation, then there is a chances of default by one party or another party. Okay, so to reduce that risk or to avoid that risk, both the parties enter into a contract means enter into a legal obligation or take their agreement or provide their agreement a legal bite. Okay, when that agreement is binding by the legal actions or legal terms and contracts, that agreement is turned into a contract. Okay, so for a agreement to become a contract, there should be enforceability by law. So the agreement contains two essential elements, which are those. First one is contract contains two essential elements. First one is agreement and the second one is enforceability by law. And now agreement contains three elements here. One is offer or proposal, then that offer or proposal should be accepted by the another party and there should be consideration. So agreement is equal to offer or proposal plus acceptance plus consideration. Then contract is equal to an agreement plus enforceability by law. So here you can see this. Contract is equal to agreement plus enforceability by law. On elaborating the above two concepts, it is obvious that contract comprises of an agreement, which is a promise or set of reciprocal promises, that a promise is the acceptance of a proposal giving rise to a binding contract. Further, section 2 subsection H requires an agreement capable of being enforceable by law before it is called contract. Where parties have made a binding contract, they created rights and obligations between themselves. Okay, whenever they are entering into an agreement by and tying that agreement to a legal obligation, then there arises a rights and obligation between the parties. One party has a right to deliver the laptop and another party has an obligation to pay the amount. Okay, here once they enter the agreement into a contract part, then there is a rights and responsibilities between the two parties. One party must exercise his right and must exercise his obligations. Okay, so if both the parties or any one party avoids or does not perform his right or obligation, then we can that another party can take legal action against the another party which has not performed his duty or which has not performed his rights or obligations. Okay, so to avoid the risk, the agreement should be tied with the legal terms and conditions. Okay, so when agreement is binded by the law, then it is called as contract. Now coming to example part, here you can see example 1. A agrees with B to sell a car for 2 lakhs to B. Okay, here A is under obligation to give car to B and B has the right to receive the car on payment of rupees 2 lakhs, and also B is under obligation to pay 2 lakhs to A and A has the right to receive 2 lakhs. Okay, here there are two parties A and B. One is agreeing to pay 2 lakh rupees and another one is agreeing to sell his car. So there are promises because here you can see A agrees with the B to sell car for 2 lakhs rupees. So B is promising to pay 2 lakh rupees to A and A has accepted that promise or proposal. Okay, when A has accepted that proposal to deliver his car and to accept rupees 2 lakhs, then that is there it created a promise. When offer is accepted and when it creates the promise, then that promise or series of promise is in law terms we can define it as a agreement. Okay, when that agreement is tied to legal terms and contract, then the legal terms and conditions, that agreement is turned into a contract. Okay, here in simple terms, A has an obligation to sell the car and right to receive rupees 2 lakhs and B has obligation to pay rupees 2 lakhs and right to receive a car. Now coming to second example, here you can see father promises his son to pay him pocket allowance of 500 every month, but he refuses to pay later. The son cannot recover the same in court of law as this is a social agreement. This is not created with an intention to create legal relationship and hence it is not a contract. Here there are promises and agreement between the father and son, but they have not created or they have not taken any legal terms and conditions, or there is not a binding contract between them. The son cannot sue the father in the court of law because the agreement has never turned into a contract here, because there is no legal terms and conditions between the father and son. Hence it is purely an agreement, social agreement, but not a contract. Okay. So, law of contract deals with only such legal obligations which has resulted from agreements. Such legal obligations must be contractual in nature. However, some obligations are outside the pure view of law of contract. Example, an obligation to maintain wife and children, an order of the court of law, etc. These are status obligations, so out of the scope of contract act. So obligation to maintain wife and children are the status obligation, so this is out of the contract act. Okay, so this does not this is not the part of Indian Contract Act 1872. Now we can see the difference between agreement and a contract. What are the differences? So this is one important topic. So agreement and contract, what are the meanings? So meaning, we have already seen every promises and every set of promises forming part of the consideration for each party, each other. Then promise plus consideration is called as agreement. So contract is agreement enforceable by law. Agreement, when added with the legal enforceability, that becomes the contract. So this is the first difference. Now second difference is scope. It is a wider term including both legal and social agreement. Okay, agreement includes both legal agreement also and the social agreement also. Social agreement means, for example, we have seen here the relationship between the father and the son, or the agreement between the father and son, that is the social agreement. And the contractual agreement also includes the agreement. So legal agreement and the contractual agreement. So this is the wider term. And contract is, it is used in a narrow sense with the specification that the contract is only legally enforceable agreement. So contract is only a legal part. When the legal part is associated with the agreement, that turns into a contract. So contract includes only legally enforceable agreement, but agreement includes both legal and the social contract. So the scope of agreement is wider and the scope of contract is narrow. Now coming to legal obligation. It may not create legal obligation. An agreement does not always grant rights to the parties, and the contract necessarily creates a legal obligation. A contract always grants certain rights to every party. So in agreement, it does not necessarily mean the parties does not necessarily to exercise their rights or obligations, and it does not create any legal claims or legal obligation on the part of the parties, because there is no legal enforceability in agreement yet. But in contract, since there is a legal enforceability, both the parties must exercise their rights and obligations. If one party fails to exercise their obligation, then the other party can sue them in court of law. Then the nature comes to the nature part. All agreements are not contract, but all contracts are agreements. Okay, so the basic foundation for all the contract is that there should be an agreement, but for agreement it is not necessary that there should be a contract. So you can get this MCQ, mark it as important, because you can get this statement there. Okay, so remember, this is important, go through this. Okay, now coming to essentials of a valid contract. What are the essential elements or essential parts to become a contract, a valid contract? As given by section 10 of Indian Contract Act 1872, and not given by section 10, but are also considered essential. Okay, so essential elements are firstly given in contract also, and there are some essential elements which are not given in the contract. Okay, so we can see those. First one is, as per the contract, the agreement should be there for to become a valid contract. Second one is free consent. Okay, third one is competency of the parties. Competency means the parties should be able to perform their rights and duties. Fourth one is lawful consideration. There must be a consideration which is agreeing with the legal terms and conditions. Then fifth one is legal object. The sixth one is not expressly declared to be void. as per section 24 to 30 and 56. The terms and conditions should not be void, should be valid. Not given under section 10, what are those essential elements? There should be two parties. Okay, so to become a contract or agreement, there should be at least two parties to the contract or to the agreement. Intention to create legal relationship. Okay, third one is fulfillment of legal formalities. Fourth one is certainty of meaning. Then fifth one is possibility of performance. Okay, so the essential elements to become a valid contract are: first one is agreement, free consent, there should be two parties, there should be intention to create legal relationship, and competency of the parties, fulfillment of legal formalities, lawful consideration, certainty of meaning, legal objects, possibility of performance, and it should not be void. So, in terms of section 10 of the Act, all agreements are the contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with the lawful object, and are not expressly declared to be void. Okay, so all agreements turns into a contract when there are two parties, and the parties should have a free consent with each other, and there should be a lawful consideration, the legal terms and conditions, and with the object should be a legal or lawful, and it should be valid. The objective between the two parties should be valid and it should not be void. In that case, that agreement turns into a contract as per section 10. So in this one line, all the essential elements has been covered. Since section 10 is not complete and exhaustive, so there are certain other sections which are also contains requirements for an agreement to be enforceable. Thus, in order to create a valid contract, the following elements should be there. First one is two parties. One cannot contract with himself. Okay, so one individual should not contract or cannot be able to contract with himself, that saying okay, I am saying to myself that okay Anuja, I am providing you rupees 10 lakh, so you can provide me a car. Okay, how can I contract the deal or per deal to purchase a car with myself only, because I only have 10 lakh rupees and I am only providing 10 lakh worth of car to me. So there should, it is never happening. Okay, so the basic thing or basic essential element to turn an agreement into a contract, that there should be two parties. A contract involves at least two parties, one party making the offer, that is the proposal, and the other party is accepting it. A contract may be made by natural persons and by other persons having legal existence. For example, the contract may be between the companies, universities, individuals. It is necessary to remember that identity of the parties be ascertainable. Okay, identity of parties should be ascertainable in the contract. For example, here, to constitute a contract of sale, there must be two parties. One must be seller and the another must be buyer. A seller and the buyer must be two different parties or persons, because a person cannot buy his own goods. Okay, if you are owning some goods, then you cannot buy it, because that though you have already owned that goods. Okay, so to enter into a contract, there should be two parties. For example, in a sale of in a contract to sale, there should be two parties. One must be a seller and another must be a buyer. Okay, so the essential element is two parties must be there. Now coming to next thing, parties must intend to create legal obligation. There must be intention on the part of the parties to create legal relationship between them. Social or domestic type of agreements are not enforceable in court of law, and hence they do not result into contract. For example, a husband agreed to pay to his wife certain amount as maintenance every month while he was abroad. Husband failed to pay the promised amount. Wife sued him for the recovery of the amount. Here, in this case, wife could not recover as it was a social agreement and the parties did not intend to create any legal relationship. Okay, when husband is agreeing to pay maintenance to a wife when he is outside the country, then there is no legal obligation to pay to the wife by the husband. This is just as a relation, as a love. He is out of his like nature of love, he is paying maintenance amount to his wife. Once he stops those maintenance amount, then wife should not sue the husband in court of law, since it is a social obligation on part of husband and there is no legal enforceability. Then it is not called as the legal relationship between husband and wife, but it is called as social relationship between the husband and wife, and it is not binding contract, and it is not the wife should not, or the wife cannot sue husband in a court of law. Okay, so in order to become a contract, there should be legal obligation or legal relationship between the parties. For example, here Mr. Lakewal promises to pay 5 lakh to his son if the son passes CA exams. On passing the exam, the son claims the money. Here the son could not recover as it was a social agreement, because there was no legal obligation between a father and the son or the husband and the wife. So those are purely a social agreements and not the contractual or legal agreements. In example 7, A sold goods to B on a condition that he must pay for the amounts of goods within 30 days. So he has sold the goods on credit and he is expecting that B will pay the amount in 30 days. Here A intended to create legal relationship with B. Hence the same is called as contract. On failure by B for making the payment on due date, A can sue him in the court of law. Okay, since there is a legal obligation or the legal relationship between A and B, once B fails to pay the amount, A can sue him in court of law. Third one is other formalities to be complied with certain cases. A contract may be written or spoken. As to legal effects, there is no difference between a written agreement and a contract made by word of mouth, that is oral agreement. But in the interest of the parties, the contract must be written. In case of certain contracts, some other formalities have to be complied with to make an agreement legally enforceable. For example, contract of insurance is not valid except as a written contract. Further, in case of certain contracts, registration of contract under the law which is in force at the time is essential for it to be valid in the case of immovable property. Thus, where there is any statutory requirement that any contract is to be made in writing or in the presence of witness, or any law relating to the registration of documents must be complied with. Okay, so here what they have mentioned is contract is either written or oral. Okay, so oral contract is also a contract and written contract is also a contract. So in order to be safe, or in order to prove the agreement between both the parties, there should be written, there should be like both the parties should have written something, those terms and conditions somewhere. Okay, legally. For example, in some cases, as the statutory requirement, for example in insurance contracts, the contract should always be in written format. If the insurance contract is in oral format, in the court of law, that is not considered as a valid contract, but it is considered as an invalid contract. So in, be it in insurance contract, it should be written contract. If you are registering any house property or any immovable property, that contract or that terms and agreement should also be written. Okay, so other formalities to be complied with in certain cases. So there are two contracts, be it written or oral, but some statutory requirements, some statutory obligations, like there should be a requirement as per the statutory law that the contract should be in a written format. So in that case, the party should enter into a written contract to make the contract valid. Now coming to fourth one, certainty of meaning. The agreement must be certain and not vague and indefinite. For example, A agrees to sell to B 100 tons of oil. There is nothing certain in order to show what kind of oil was intended for. Okay, so the contract should be certain, means in contract you should explain everything. If you are selling a car, then you should mention which car you are selling, when you are selling, at what price you are selling, to whom you are selling. All those certain things should be mentioned in a contract. The contract should not simply say that, okay, I am going to sell a car to Mr. Rohan. Okay, so here you have mentioned to whom you are going to sell a car, but you have not mentioned at what price you are going to sell or at which model you are going to sell. So the contract should be certain. It should contain each and everything agreed between the parties. In example 9, you can see XYZ Limited agrees to lease the land to Mr. A for indefinite period, okay, indefinite years. The contract is not valid as the period of lease is not mentioned here. So, here in first example, example 8, there is no mention of the kind of coil, and in example 9 you can see there is no mention of the period of lease. Okay, so this contract is a vague or indefinite contract. So the contract should contain a certain meaning or certain words or the agreed terms in the contract, then that contract is called as valid contract. Now coming to fifth point, possibility of performance of an agreement. The terms of the agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. So whenever you are agreeing for any performance of the obligation, that performance of the obligation should be possible. Okay, it should not be like that the one party is unable or it is never possible for the other party to perform those tasks. So here example in example you can see A agrees with B to discover treasure by magic. The agreement cannot be enforced as it is not possible to be performed. You cannot perform the magic and you cannot find the treasure by magic. It is impossible. So whenever both the parties are agreeing for any impossible things, then by default it is never going to convert into a contract, because both the parties are agreeing to impossible things. Okay, so to become a valid contract there should be possibility of performance of an agreement. Now according to section 10 of the Indian Contract Act 1872, the following are the essential elements of the valid contract. So first here we have seen out of or except section 10 what are the essential elements of the contract. First one is there should be two parties. Second one is parties must intend to create a legal obligation. Third one is other formalities to be complied with in the certain cases. Fourth one is certainty of the meaning. Then the fifth one is possibility of performance of an agreement. Now we will see what are those essential elements which are forming part of section 10. So the first one is offer and acceptance or an agreement. Okay, an agreement is the first essential element of a valid contract. According to section 2 subsection E of the Indian Contract Act 1872, every promise and every set of promises forming consideration for each other is an agreement, as we saw earlier. And according to section 2 subsection B, a proposal when accepted becomes a promise. An agreement is an outcome of offer and acceptance of a consideration. So to become a valid contract there should be offer and acceptance of an offer in an agreement. First thing is done. Now second thing is free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense. This can also be understood as the identity of minds in understanding the terms consensus and idem. Consensus ad idem. Okay, further, such consent must be free. So, to become a valid contract, two parties must agree to the similar things. So, one party is agreeing to one thing and another party is agreeing to another thing. There should not be any contract between those parties, because both the parties are agreeing to different things only. Okay, so to become a valid contract the mind should be same. Both the parties should think in a similar way or agree to similar things. Then in that case that agreement is called as the valid contract. Okay, so here you can see consent would be considered as free consent if it is not caused by coercion. Coercion means force. If one party is forcing another party to agree to the contract, then that is called as contract by coercion but not by a free will. So there should be free consent. One party should or both the parties should freely accept the terms and conditions to become a valid contract. For example, here you can see A, who wants two cars, is selling red car to B. B thinks he is purchasing black car. There is no consensus ad idem and hence no contract, because both the parties are thinking in a different way. A is thinking that he is selling red car, but B is thinking that he is purchasing black car. If they both the parties are not agreeing or not thinking in the same way, then there is no contract. To determine the consensus ad idem, so remember this term, okay, the language of the contract should be clearly drafted. So here comes the part of written contract. Thus, if A says B, will you buy my red car for 3 lakh? B says yes to it. There is said to be consensus ad idem, that is, the meaning is taken in the same sense by both the parties. Here A is clearly mentioning that will you buy my red car, and the B is also thinking that okay, A is selling red car and I should purchase red car, or I am willing to purchase red car. Then both the parties are thinking in the same way, because A is thinking that he is selling red car and B is also thinking that he is purchasing red car. In this case, there is consensus ad idem, that is, it is taken in the same sense by both the parties. Now coming to example 12. A threatened to shoot B if B does not lend him rupees 2 lakhs and B agreed to it. Here the agreement is entered into under coercion and hence not valid contract, because B has agreed to the terms out of fear. Okay, A threatened him to kill if he does not pay, or if he does not lend him rupees 2 lakh. Out of fear, B has agreed to his terms, or B has agreed to his proposal or offer. In that case, it is not a valid contract. The contract has become a contract out of fear of B. That is, a contract is by coercion. So this is not a valid contract. Student may note that terms coercion, undue influence, fraud, misrepresentation, mistake are explained in Unit 3. So in Unit 3, you will get to know more about this coercion part. Okay. So just remember here now that the contract should not be entered into by any fraud, misrepresentation, or by threatening to kill someone, or by fear. So contract should be purely out of free will or free consent. Now coming to third thing, capacity of the parties. Capacity to contract means the legal ability of a person to enter into a valid contract. Section 11 of the Indian Contract Act specifies that every person is competent to contract who is of the age of majority. He should not be minor. Minor means the person who is below the 18 years of age according to the law to which he is subject, and he is of sound mind. Sound mind means he is able to understand the agreement or the promise or terms and conditions clearly. He should be of a sound mind and he should not be of a unsound mind. He is not otherwise disqualified from contracting by any law to which he is subject. Okay, capacity of the parties here comes when the party is of the sound mind and he can enter into a contract, or he is not disqualified by any court of law for entering into a contract, and he is a major, he is not a minor. In that case, parties can enter into a contract. A person, for being competent to contract, must fulfill all the above three qualifications. These three conditions should be fulfilled by the parties if we are considering the capacity of the parties, okay, to enter into a contract. Here you can see qualification A refers to the age of contracting person, that is, the person entering into a contract must be of 18 years of age. Okay, below 18 years he is considered as a minor and he should not enter, a minor cannot enter into a contract with any person. Okay, so person below 18 years of the age are considered minor, therefore incompetent to contract. Qualification B requires a person should be of a sound mind, that is, he should be in his senses so that he understand the implication of the contract at the time of entering into a contract. A lunatic or idiot or drunken person, or the person under influence of some intoxicants like drugs, is not supposed to be a person of sound mind. Okay, so if someone A is offering drinks to B, and in that drinking sense he has entered into some contract, or he has signed a property paper and he has transferred all his properties to A, So when he was entering into that contract, or when he was signing those papers, or when he was transferring this property, he was not in his senses. So when he is not in his senses while entering into a contract, that contract is not considered as a valid contract. If B proves in a court of law that when he was entering into a contract he was not in his senses, then court may reject that contract, and in court of law that contract becomes invalid. Okay, so to enter into a contract, the person must be in his senses. He should be of a sound mind. He should not be an idiot, or he should not be under any intoxicants, or he should not have taken any drugs, or he should not have taken any alcohol, etc. He should be in his pure sense while entering into his contract. Now, qualification C requires that a person entering into a contract should not be disqualified by his status in entering into such contract. Such persons are an alien enemy, foreign sovereigns, convicts, etc. They are disqualified unless they fulfill certain formalities required by law. Okay, so here you can see foreign sovereigns or any enemy or convicts or the criminals are not be able to enter into a contract. Like certain persons are disqualified by the court of law to enter into a contract. If they are entering into a contract, they should fulfill certain formalities if required by law, then only they can enter into a contract, otherwise they are not competent to enter into a contract. So contracts entered by persons not competent to contract are not valid, those are void contracts. Now coming to fourth part, consideration, it is referred to as quid pro quo, something in return. So remember this term, this is very important for your MCQ. Okay, so quid pro quo means something in return. You can relate quid pro with consideration. A valuable consideration in the sense of law must consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by another party. So, to become a valid contract, the consideration should be valid. The contract should be entered into by both the parties for something in return. Okay, so then that is called as a valid contract, otherwise not. For example, here you can see A agrees to sell his books to B for rupees 100. B promises to pay rupees 100 in consideration for A's promise to sell his books. A's promise to sell books is the consideration for B's promise to pay. Okay, for A, rupees 100 is the consideration, for B, books are the consideration. So A and B enters into a contract for a particular consideration for rupees 100 and for books. So this is a valid contract. Now coming to lawful consideration and object. The consideration and the object of the agreement must be lawful. Section 23 states that the consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provision of law. If it is fraudulent or involves any injury to the person, property of another, or court, regard it as immoral or opposite to public policy. Okay, consideration should be lawful. Consideration should not harm public interest, or consideration should not harm any other party. So the contract becomes a valid contract only if it has a lawful consideration and lawful object. Okay, for example, here you can see A promises to drop prosecution instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is void as its object is unlawful. The object here is unlawful, so this contract has become void. Example 15, A agrees to sell his house to B against 100 kgs of cocaine. Cocaine is a drug. Drug or supplying drug is considered as a criminal thing and in terms of law. So if A is agreeing to sell his house against 100 kgs of cocaine, such agreement is illegal in as the consideration is unlawful. Consideration is not a lawful consideration, so this contract has become illegal and void. Now coming to sixth thing, not expressly declared to be void. The agreement entered into must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. If the contract contains or the agreement contract contains any unlawful considerations or which is prohibited by law, the both the parties are entering into some activities which is illegal, like supplying of the drugs or supplying of or entering into any like anti-monetary policies, or if both the parties are scamming someone, or if both the parties are supplying or involved in activity which is illegal in terms of or in the eyes of court of law, then that contract becomes a void contract. If it is the activity prohibited by law, and then those activities are undertaken by both the parties, and they are entering into or agreeing into enter into illegal activity, then that contract is called as void contract. A void agreement is one without any legal effect. Okay. For example, 16, threat to commit murder or making or publishing defamatory statements or entering into an agreement which are opposite to public policy are illegal in nature. Similarly, any agreement in restraint of trade, marriage, legal proceedings, etc., are classic examples of void agreements. Okay, so these are some of the examples of void agreements. So to become a part or to make a contract a valid contract, the agreement should also be a valid. Okay, agreement should not be void agreement. So these are some of the elements under section 10. So we'll go through once again. So what are those elements? First one is offer and acceptance of an offer in an agreement. Second one is free consent. Now third one is capacity of the parties. Fourth one is consideration, and fifth one is lawful consideration and object, and sixth one is not expressly declared to be void. Okay, so these are the essential elements to become to make a contract a valid contract. Now coming to types of contracts. So here you can see types of contract on the basis of validity or enforceability, on the basis of formation, and on the basis of performance. Okay, this is also important, make a note of it. Types of contracts on the basis of validity or enforceability, on the basis of formation, and on the basis of performance. So on the basis of validity, you can see valid contracts, void contracts, voidable contracts, illegal agreements, and unforceable contracts. On the basis of formation, express contracts, implied contracts, quasi contracts. This is very important, you can get questions from this. And e contracts. Now on the basis of performance, executed contract and executory contract. Under executory contract you have unilateral contract and bilateral contract. We will see one by one the types of contracts. Okay, so first we will see on the basis of validity. So first one is valid contract. An agreement which is binding and enforceable is a valid contract. It contains all the essential elements of a valid contract. Okay, if an agreement contains all the essential elements which we discussed few minutes ago, if an agreement contains all those elements, then that is called as a valid contract. If it contains a valid consideration, if it is contains a lawful consideration, if both the parties agreeing to the same things, if parties to the contract are competent to enter into a contract, then this is called as a valid contract. For example, if I'm so sorry. For example, A asks B if he wants to buy his bike for 50,000. B agrees to buy bike. It is an agreement which is enforceable by law, hence it is a valid contract. So valid contract is the one which has all the essential element to become a valid contract, then it is called as a valid contract. Okay, so simple, right? Now next coming to void contract. Section 2 subsection J states as follows. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus, a void contract is one which cannot be enforced by court of law. For example, Mr. X agrees to write a book with the publisher. Such contract is valid, but after few days X dies in an accident. Here the contract becomes void due to impossibility of performance of the contract, because X has entered into a contract with the publisher. There are two parties to a contract. If X dies in an accident, then one party has died, and then only single party remains in the contract. So the basic condition of the valid contract is that, basic elements of the valid contract is that there should be two parties to the contract. Okay, when X has died, there is only one party to the contract, so it is not enforceable only. So if the contract is not enforceable in the law, then that contract is called as void contract. Okay, thus a valid contract, when cannot be performed because of some uncalled happening, becomes void. Example 19, a contract with B, owner of the factory, for supply of 10 tons of sugar. But before the supply is effected, the fire caught in the factory, unseen or unexpected event has happened, and everything was destroyed. Here the main object, the sugar, okay, which the parties have entered into a contract for the sugar, that sugar caught fire and that sugar was destroyed. If there is no object, if there is no supply of sugar, then there is no contract. Then the valid contract has become a void contract, okay, due to some unexpected happenings or unexpected events. It may be added by way of clarification here that when a contract is void, it is not a contract at all, but for the purpose of identifying it, it has to be called as a void contract. Okay, so when the contract is void, then it is not actually a contract, but to call it or to refer it, we have considered it as a void contract, or we have named it as a void contract. Now coming to voidable contract. Section 2 subsection I defines that an agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of the other or others, is voidable contract. Okay, so there are two or more parties in the contract and it is enforceable by law as per the one party, but it is not enforceable by law as per the other party. In that case, that contract becomes the voidable contract at the other party. Okay, so we'll deeply see it in a detailed way here. This in fact means where one of the parties to the agreement is in a position or is legally entitled or authorized to avoid performing his part, then this agreement is treated and becomes a voidable contract. Okay, when one party can avoid his part of obligation in a contract, then that contract is called as voidable contract as per that party, the one who is able to avoid his obligations or rights, then this contract becomes voidable on that party. Okay, for example, here you can see X promises, first point is following are the situations. So here we have explained the situations where a contract becomes voidable contract. First one is when the consent of the party is not free, is caused by a coercion, undue influence, misrepresentation, or fraud. Okay, so one of the most essential element to become a valid contract is that the free consent. The parties should have a free consent to the contract. So when the consent of the party is not free and it is caused by out of fear, misrepresentation, fraud, or threatening to kill the party, then this contract becomes a voidable contract. Then the other party can avoid the obligation. Okay, in that case, that contract becomes a voidable contract. For example, here X promises to sell his scooter to Y for 1 lakh. However, the consent of X has been procured by Y at the gunpoint. X is an aggrieved party here, and the contract is voidable at his option but not on the option of the Y. It means if X accepts the contract becomes valid contract, then Y has no option of rescinding the contract. Now coming to second thing, when a person just a minute. Okay, when a person promises to do something for another person but the other person prevents him from performing his promise, the contract becomes voidable at the option of first person. Okay, when there are two parties, when one person is promising to do something to another person but the another person is prohibiting or making something that the first party is unable to perform his obligation, then this contract becomes voidable at the part of first party. Okay, for example, here there is a contract between A and B to sell a car. of A to B for 2 lakh rupees. On due date of performance, A asks B that he does not want to sell his car. Here, contract is voidable at the option of B. Okay, so the A and B has entered into a contract. So first contract was to A will sell the car to B for rupees 2 lakh. Okay, when there was a day when day of the performance, that when A should have been sold his car to B, on that day A rejects to sell the car. In that case, the contract is voidable at the option of the B. B can enter into a contract, or B can agree to whatever A is saying, and does not pay 2 lakh rupees, and he agrees that he will not buy the car, or he can make A sell his car. Okay, here the aggrieved party is B. The B has the option either to accept the terms of the A, or he can reject the terms of the A. If B agrees with the A, then the contract gets cancelled. Or if B says that no, I want to purchase this car because we have entered into a contract, then A should enter into a contract and A should sell his car. So this contract becomes voidable at the option of the B. B can accept the whatever A is saying, or he can reject whatever A is saying. So here contract becomes voidable at the option of B. Now coming to third thing, when a party to a contract promises to perform a work within a specified time, could not perform within that time, the contract is voidable at the option of the promisee. A agrees to construct, for example, here you can see A agrees to construct a house for B up to 31st March 2022, but A could not complete the house on that date. Here the contract is voidable at the option of B. B can reject the contract. If like A has agreed or promised B that he will make his house, or he will construct his house by this date, by 31st March. If A is unable to perform his duty, then B can cancel his contract. Okay, B has the right to either accept and agree for an extended date, or he can cancel the contract. So here B has the option to either accept or reject the contract. So the contract is voidable at the option of B. Now here you can see at this juncture, it would be desirable to know the distinction between void contract and voidable contract. So there are two contracts, void and voidable. So it is necessary for us to know what are the differences between void and voidable contract. So we will see one by one the differences. Okay. So meaning, first one, void contract. A contract ceases to be enforceable by law, becomes void when it ceases to be enforceable, as we have seen few minutes ago the meaning of the void contract. And the voidable contract is an agreement which is enforceable by law at the option of the one party or the more of the parties, but not at the option of the other or others, is a voidable contract. Other party can either accept or reject the contract, then we can call it as a voidable contract. If in a void contract there is no enforceability of the law, then it is called as a void contract. Enforceability. A void contract cannot be enforced at all. It is enforceable only at the option of the aggrieved party and not at the option of the other party. Please note that this is important MCQ point. Okay, this is an important MCQ point. This may be asked by in your exam, so prepare accordingly. Now third thing is cause. A contract becomes void due to change in law or change in circumstances beyond the contemplation of the parties, due to uncertain events or the events which are not in control of the parties. Then that contract becomes a void contract, because the legal enforceability is not there when uncertain event happens. So this contract becomes a void contract. But under voidable contract, a contract becomes a voidable contract if the consent of the party was not free. So these are the main differences between the void contract and the voidable contract. Now the fourth one is performance of a contract. A void contract cannot be performed at all because the enforceability of the law is not there and the contract is not a contract. So this I'm so sorry. So this contract cannot be performed at all. But in the voidable contract, if the aggrieved party does not within a reasonable time exercises his right to avoid the contract, any party can sue the other for claiming the performance of the contract. If the aggrieved party does not within a reasonable time exercise his right to avoid the contract, then that contract becomes enforceable. Then any party can sue the other party for performance of the contract. Okay. So in comparison to rights, a void contract does not grant any legal remedy to any party. The party whose consent was not free has the right to rescind the contract, that is, cancel the contract or reject the contract within or avoid the contract within a reasonable time. If so rescinded, it becomes a void contract, and if it is not rescinded, it becomes a valid contract. Now, fourth one is illegal contract. It is a contract. So this is the type of a contract, okay, on the basis of validity. The fourth one is illegal contract. It is a contract which the law forbids to be made. The court will not enforce such contract, but also the connected contracts. All illegal agreements are void, but all void agreements are not necessarily be illegal. Okay, so all illegal agreements are, this is important statement. Please note that this can be asked in your MCQ question. All illegal agreements are void contract, but all void agreements are not illegal. Okay, despite this, there is a similarity between them, is that in both the cases they are void ab initio and cannot be enforced by law. Okay, similarity between illegal contract and void contract is that these are not enforceable by law, and all illegal contracts are void contracts, but all void contracts are not illegal contract. So void contract is one where enforceability of law is not there. It can be void contract due to unforeseen events or the events which are not in the control of the parties. Okay, so that is not necessarily the illegal activity. For example, a fire caught in a warehouse or earthquake, all these are an unforeseeable events or non-controllable events. So this is not something illegal. So all void contracts are not illegal contracts, but illegal contracts are void contract because the illegal contract is not enforceable in terms of law. So that contract becomes a void contract. Okay. So common thing between illegal and void contract is that non-enforceability of a law. For example, a contract that is immoral or opposite to the public interest or public policy are illegal in nature. Similarly, if R agrees with S to purchase brown sugar, it is an illegal agreement. Or if R agrees to purchase drugs, then it is an illegal agreement. Okay. According to Section 2, subsection G of the Indian Contract Act, an agreement not enforceable by law is void. The Act has specified various factors due to which an agreement may be considered as void agreement, which we have seen earlier. One of these factors is unlawfulness of the object and consideration of the contract, that is, illegality of the contract, which makes it void. The illegal and void agreement differ from each other in the following respect. Now we can see what are the major differences between illegal and void contract. So first, in terms of scope, a void contract is not necessarily illegal. Okay, void contract can be due to some unforeseen events, so it is not necessarily be an illegal contract or not necessarily involve illegal activity. But illegal agreement always void, as we saw few minutes ago. Okay, so nature not forbidden under the law are forbidden by law. So earthquake or fire are not forbidden by law, those are non-controllable. But in illegal agreement, certain activities are prohibited by the law or forbidden by law to enter into a party, such as the purchase of the drugs or murder or fraud, or these are illegal activities, and these are forbidden or prohibited by law. Punishment. Parties are not liable for any punishment under law because this does not involve any illegal activity, but parties to the illegal agreement are liable for punishment as per law. As per collateral agreement, it is not necessary that agreements collateral to void agreements may also be void. It may be valid also. Agreements collateral to illegal agreements are always void agreement. Okay, so the one activity which is related to this contract, which is collateral to this contract, it is not necessary that collateral activity or joint activity is also void contract. Maybe that activity is a valid contract, maybe that activity involves enforceability of law. So, but in illegal agreement, any collateral agreement, any activity which is related to illegal part, illegal contract, that automatically that collateral activity also becomes illegal in illegal contract, okay, or void contract or void agreement. So now coming to fifth type, unforeseeable contract, where a contract is good in substance but because of some technical defect, that is absence in writing, barred by limitation, etc., one or both the parties cannot sue upon it. It is described as an unforeseeable contract. If it is not written in somewhere, then other party cannot prove the existence of the contract, and that other party cannot sue the another party. So in that case, it is considered as an unforeseeable contract. For example, you can see A bought goods from B in 2018, but no payment was made till 2022. B cannot sue A for the payment in 2022 as it has crossed the 3 years and barred by limitation act. There is a limitation act under which the payment should be made within 3 years, and B has not paid the amount till 2022, that is more than 3 years. So B cannot sue, sorry, A has not paid, so B cannot sue for the payment in 2022 as it has crossed 3 years and barred by the limitation act. A good debt becomes unforeseeable after the period of 3 years as barred by the limitation act. So this is an unforeseeable contract. Similarly, an agreement for transfer of immovable property should be written for being enforceable. So as per the law or as per statutory requirement, any transferring of immovable property should contain a proper written agreement or a written contract. If written contract is absent in the contract, then that is called as unforeseeable contract. That is not legally bindable, okay, or not legally enforceable. So we have seen the types of contracts on the basis of validity. So first one is valid contract, second one is void contract, and third one is voidable contract, and fourth one is, just a minute, illegal contract, and fifth one is uh, just now we saw unforeseeable contract, okay. So we can see remaining types of the contracts in next video. So we have crossed 1 hour, so I will make part 2 of this video, so we can see remaining part in next upcoming video. So till then, go through the study material and go through all the parts which we have seen today. Read all the parts carefully, and if you have any doubts, then please ask your questions in the comment section below, and I'll see your question and try to answer those questions. So thank you and enjoy your studies and all the best. Bye bye. Stay tuned for more videos. Till then, subscribe, like and share. Bye bye.